Justice Swaminathan was appointed as Judge of High Court of Tamil Nadu on 28/6/2017. Today, out of his experience as advocate, as a nationalist fighter, and as a judge, he has to say many things, because we have been working for the class was in the ground trodden or village levels. Out of his rich experience and knowledge, we may able to discharge our activities, duties. Today, he is with us. I welcome on behalf of Adhivakta Parishad, and I request Shri K. Srinivasan ji, our former president, Kerala unit, to welcome Shri Swaminathan ji with traditional Kerala shot. At the same time, I request Shri Krishna Sheni and Krishna Kumar to honor our Bisco. Honor Justice Swaminathan. Without wasting our time, I now request Honorable Judge Shri G.R. Swaminathan to address us.
Good morning to one and all present here. You all know there are two categories. One is Karyakarta category, other is Baudik Pramukh category. I belong to the first category. Srinivasamurthy ji has asked me to give a 30-minute presentation, probably thinking I'll give some solid academic stuff. Sorry, I'm not going to do that. I'll only be telling you a few stories and some experiences within these 25 to 30 minutes. At the outset, I must apologize to all of you for not being able to speak in Hindi. I'm really sorry about it. See, some 28 years ago, I had attended Adhivakta Parishad National Conference. I think it was the year 1994. Around that time, militancy was at its height in Kashmir. Some militants had been holed up in a mosque. They were surrounded by the security forces. The militants said, if you enter the campus, we'll blast the mosque. So that is their respect for their religion. So the standoff was continuing for quite some time. It was Ramzan and some court, I forget which. Friends, believe me, it passed an order, send them biryani during this period. The militants were asked to be fed with biryani during that period. And it was in that background the conference was taking place, and when my turn to speak as a delegate from Tamil Nadu came, I said, I have read Solomon on jurisprudence, Dias on jurisprudence, Bodenheimer on jurisprudence, but the first time I am coming across biryani jurisprudence. So in 28 years, there has been a paradigm shift, and I am fortunate to speak on Bhartiya Jurisprudence. And I again apologize, I am constrained to speak in English because I really do not know Hindi. And any one of you may take up the task of teaching me Hindi. I will take it as a New Year resolution for 2023. But I don't want to learn Hindi from Srinivasa Murthy ji. He will teach me Telugu. So choose me some teachers from Haryana or Madhya Pradesh, and I really hope to address my next, when I come visit Adhyukta Professional Conference next time, I really hope to address you in Hindi. Having said that, friends, I come from Madurai, the land associated with Silappadiharam. It is one of the 5 great Tamil epics. It is about Kannagi. Kannagi was a great woman. She was from a very wealthy family. She got married to one Kovalan. But Kovalan developed a fancy for a dance. The king realized, oh God, he is not a thief. I am the thief. Had committed a blunder. He was overcome by remorse and guilt. He suffered a cardiac arrest and he died there itself. And that is what the Silappadiharam is all about. One of the great epics of Tamil literature. Whenever a chief justice or a new judge will come to Madurai and the bar association will give him his welcome address, they will narrate the story. And as a judge, I have to hear the story every time. I used to tell myself, thank God, judicial infallibility is no longer a condition of service. It sent a shiver down my spine. Oh, if I pass a wrong judgment, if death is the consequence, what will happen to us? Then the collegium will have no other job but to keep recommending names for appointment. It will be a 24/7 job. But then I am making 2 assumptions here. One is the members of the collegium are Amartasya Putra. And the other assumption is Law Minister Kiran Raju will not play hardball with the collegium. So, subject to these 2 assumptions. Friends, I said the Silappadiharam was all about giving a wrong judgment in a case. But what is our moral? Our moral is that when it comes to handing down capital punishments, it should be beyond any error. It cannot be to satisfy the collective conscience of anybody. That is a moral I derive from this story. And talking of capital punishment, and just last month, 6 convicts in Rajiv Gandhi case, they were originally sentenced to death, then there was commutation to life imprisonment, and after 30 years have gone, they have been allowed to go scot-free. And there was one seminar in Chennai, and one of the convicts, he was the star speaker there. And many of us really felt disturbed by that, including myself. But then, I came across one beautiful passage in Valmiki Ramayana. Beautiful passage. The war had ended. Hanuman goes to Ashokavana to bring back Sita. There he sees all the Rakshasis who are tormenting Sita. And Hanuman goes into a rage. He asks permission to Sita Ma. Shall I kill these women? Shall I break their bones? Then Sita says, Hanuman, don't you know that what the bear told the tiger? Don't you know that story? And she quotes that. It's a very beautiful story. A hunter was chased by a tiger. He ran and ran for his life. Then to escape from the tiger, he climbs onto a tree. But the tree happens to be the abode of one bear. Then tiger tells the bear, look, he is a hunter. He is our common enemy. Therefore, push him down. But then the bear says, no, 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 no. He has come to my house seeking refuge. It is not our dharma to turn a refugee away. I will not do that. Then tiger said, all right, one day he has to come down. Let me see how long he is hold up there in that tree. The tiger was waiting on the ground. Evening came, then night fell, bear goes to sleep. The tiger tells the man, look, I am hungry. I don't bother about my menu. Whether it be the flesh of a human being or that of a bear, no problem. Just push the bear down. I'll eat the bear and go away. Then you can return to your village. See, man being man, this appeared to be a good deal. So he goes up stealthily, pushed down the bear. But the bear, it is used to falling down from the tree branch. It did not fall to the ground, it held on to a branch and then it climbed back. And like the modern day politicians, the tiger immediately changed its dialogue. It now addressed the bear. See, you gave him refuge, but see what he has done. So, better push the man down and I'll eat him and go away. Then the bear said, friends, I request all of you to go back to Valmiki Ramayana, read this original shloka. What Sita tells. Actually, Sita is only quoting the bear. She says, my behavior will not be conditioned by that man. Bear tells the tiger, even if he is deserving death sentence, still we can forgive them. Friends, when I read this shloka from Ramayana, I was able to come to terms with this recent developments of giving remission, letting go all these Rajiv Gandhi case convicts. So Article 72 of the Constitution, 433 of CRPC, for all that we have a basis in Ramayana itself. In fact, that is exactly what Justice Abdul Nazir spoke to us last year in Advaita Parishad conference held at Hyderabad. When he said, decolonize the Indian judiciary, when he said, let us go back to our roots, when he spoke of the great features of the Bhartiya Jurisprudence, it was really meaning this. But then, after Abdul Nasir J spoke, all of you would have read, it invited such strong reactions from the so-called liberal left. One writer said, Justice Abdul Nazir has breached his constitutional oath. In Frontline magazine, there was an article by Shamsud Islam, objection, Your Honor. We have gathered here to bang the gavel hard and declare objection overruled. Is it not? Friends, what are we supposed to do? I began my presentation by saying, I am a Karyakarta. I only believe in giving tips alone. I have drawn up 5 or 6 tips. Let me start. First one, all of us present here will once again reread Justice Abdul Nazir's lecture given under the auspices of Adivakta Parishad last year, line by line. It is in English and if possible, let us translate it in our respective languages and have it distributed as wide as possible through WhatsApp and every possible source. I can proudly tell you, I got it translated in Tamil and our beloved Srinivasa Murthy ji released it in Madurai a few months back. The translation in Tamil has already been done. And I would like to know if in other languages a similar effort has already been taken. First thing. Second is, all of us must go back to Justice Ramajoy's book on our constitutional history. It's a fairly bulky volume and I do not know if it is still in print. I bought it when it was published by Tripathi. It's still print? Excellent. Yes, exactly. Tripathi. Now who has published it? No, Tripathi is no longer there. Okay, it is still there? Okay then. Oh, in Amazon is available, that's good. Now, let all of us, each and every one of us present here, we will start our reading of Ramojoy's book. It may take, say, maybe a few months, but let us make it a point to read it in full. Friends, when it is jurisprudence, we all think it's only John Austin and others. But if we go back to Ramojoy's, we will find that every theme that any book on jurisprudence deals with, what is law, what is right, what is duty, what is obligation, what is possession, what are judicial remedies, everything, every theme has been exhaustively dealt with in our ancient Bhartiya jurisprudence. You just have to read Ramojoy's and then you will realize the truth of what I am now saying. Thirdly, please listen to some of the lectures of Justice P. Ramasubramanian that are available in the YouTube. Under the Aegis of Manthan Foundation, he's given a talk on the Indian ethics and the law today. Just listen to it. Reading Ramojoy's may be a little difficult, but listening to Justice Ramasubramanian will be so easy. And I think that will provide us an excellent and easy introduction to Bharatiya jurisprudence. Just as Valmiki is in Sanskrit, Tulsidas in Hindi, we have Kamban in Tamil. Just as Ramasubramanian has written a scholarly work on law and justice in Kamban's Ramayana. It's a very small book and I am told that the judges himself translating it into English. And from that book, I will quote only 3 instances. In the very opening chapter, the judge traces a link between law and the black color. For a very long time, I was quite uncomfortable with the black dress that we lawyers and judges wear. But in Kamban, he says, who is the god of justice? Yamadharma Raja. He is black in color. What is his vehicle? Buffalo. It is black in color. Of course, because the vehicle of the justice god we have in Buffalo, our legal system is also moving very, very slowly. I wish he had a horse as his vehicle. But then the link between the black color and the law, that he traces. Then coming to the episode of Ahalya, you know, Indra had a lustful eye on Ahalya. So when Gautama Muni was absent, he impersonates the Gautama Muni and has a relationship with Ahalya. Kamban raises a question, will you charge Ahalya with adultery? What is adultery? Having sex with a person other than the spouse. That is adultery. But Ahalya was not guilty of adultery because to constitute a crime, you need 2 elements, the physical act and the intention. Ahalya was thinking she was with her husband. She did not have the criminal intention. Therefore, the poet concludes she was not guilty of adultery. Mens rea concept, whether the English people gave this concept mens rea? No. The Bhartiya jurisprudence was already endowed with the concept of mens rea. Then we have, again, same Ramayana, the war scene. Indrajit and Lakshmana are locked in a terrible combat. You know, Indrajit can do the vanishing act, disappearing act. And Lakshmana is not able to find out where he is. So out of sheer anger, he wants to unleash Brahmastra. Brahmastra is our equivalent of pressing the nuclear button, atomic bomb. When he is about to do that, Rama says, no, Lakshmana, you won't do this. Why? Yes, you will kill Indrajit, but along with Indrajit, you will also kill innocents. Our dharma does not permit that. See, some 30 years ago when Iraqi war was going on, their aim was to kill Saddam Hussein, but hundreds and thousands of innocents were killed. A question is asked to President George Bush in a press conference, sir, what about this killing of innocents? He shrugged his shoulder and said, collateral damage. Western jurisprudence will accept collateral damage. Bhartiya jurisprudence will not accept collateral damage. So many aspects like that. Even res judicata, every concept you will find in our Bhartiya jurisprudence. Well, having spoken of Ramayana, can we leave behind the Mahabharata? No. Friends, I recently came across a tiny booklet by one advocate by name Sridhar Pattaraju. He's a Delhi-based advocate, I suppose. He has culled out maxims from Mahabharata. You can just run through that. And one maxim alone I will cite. Vidura is telling how do, just as a honeybee collects honey from the various flowers, tax should be collected from the people. It should be a painless process. There is a maxim in Mahabharata. Friends, can there be a better basis for tax jurisprudence other than this? So whenever I wish the GST authorities are acquainted with this principle. Then Arthashastra, Manudharma Shastra, Yajnavalkya, so many are there. So friends, the resolution that we are going to now form is that we will undertake a study of all these subjects. So this conference will be the first step that we are now going to take. But there is one clarification. We are not going to wholesale import what was there. In fact, in the previous session, our good friend Vikram Banerjee saying, no, it is not going to be a blind application of what was there. What is not in tune with the current needs and times, we will not accept that. Certain aspects of the past were absolutely objectionable. We will simply cut them away, chop them off. We won't bring them back. I will even go to the extent of saying, whatever is not in accord with constitutional morality, that we will not even accept. So to that extent we will go. So when we say Bharatiya jurisprudence, we mean those which are capable of meeting the current challenges, only those aspects that we will seek to bring them back. Friends, what is unique about Bharatiya jurisprudence? As far as I could see, the fidelity to truth, that I find as the most unique feature of Bharatiya jurisprudence. We will have heard of the Satyakama story. Satyakama was the son of Jabala. Jabala was given to free dating and free love and sex. Satyakama asks the mother one day, Amma, who is my father? Jabala tells the son, child, I really don't know. And Satyakama grows up and the time has come for him to join the school. Those days, ashrams were the places where education was imparted. He went to some top-ranked Muni, a Rishi, and seeks admission. And the Muni does an interview, wants to do a background check. Asks Satyakama, well, who is your father? And Satyakama recounts what his mother told him. He got instant admission because Satyakama was truthful. He did not gloss over or utter a falsehood. So the Rishi takes him. And Professor Mahadev Ranade, in his exhaustive survey of Upanishads, says truthfulness is the fundamental feature of our jurisprudence. Friends, I had an occasion to apply that principle. Recently, last month I was holding the service portfolio. Candidates who last in the recruitment process exam conducted by Teachers Recruitment Board, many of them were before me, they had filed writ petitions. And friends, you must believe me when I say this. One of the questions was, who defeated Napoleon in the Battle of Waterloo? Even a child of history will say, Duke of Wellington. Any child will say. But the key answer of TRB was that the recruitment board was one Hefferman. I don't know who that man is. Persons who wrote Wellington, they were not given marks. And they come to me and say, Judge, see what is this? When I expressed my surprise, the standing counsel for the board frankly told me there is a judgment of Justice Madan Lokur which says the court cannot second guess the correctness of the key answers. You can't do that. Because it will open Pandora's box and it will open floodgates, therefore the courts can't second guess. I asked him a question. All right, who is the Prime Minister of India? Somebody answers Narendra Modi. But the key answer is Rahul Gandhi. Is it absurd? I asked. Friends, it is a judgment. I am not merely for rhetoric, I am not saying it is a judgment also. And I quoted Mandukya Upanishad. We say Satyameva Jayate, truth triumphs. So the true answer is Duke of Wellington. But if you give a false answer as the correct key, I will not accept it. And I said between Mandukya Upanishad and Madan Lokur, I prefer Mandukya Upanishad. But I am only a High Court judge. Above me there is a division bench. Above that there is a great Supreme Court. So therefore, I had to, carefully negotiate my way through. Fortunately for me, there was a 1983 or 84 judgment, 3 judges bench of Justice Chandrachud, which said under certain exceptional cases where something is demonstrably wrong, you can even overrule the key answer. So with some qualifications which I did here and there, I was able to say, no, mark should be awarded to the person who has given the correct answer. This is Bhartiya Jurisprudence. Being truthful, the truthfulness is ultimate. Then I give you another experience of mine. There was a guy by name Subramanian. He was a transport corporation driver. He was driving his bus. He hit a two-wheeler from behind. The person fell down, suffered some injury. He was taken to hospital. There he died. The Subramanian was charged with reckless driving, negligent driving, 304A of IPC. He was given sentence by the courts below. The matter comes to the High Court and I was his counsel. I was going through the papers. I came across a very interesting earlier judgment. I decided to make use of it. I told the judge, the person did not die on the spot, he died elsewhere. What is there to connect Subramaniam with the cause, the death, the post-mortem report? The post-mortem report in this case was not marked by the doctor, it was marked through the essay of police. The judgment said that any document must be marked through the doctor because he is the author of the document, not the police. I said, since the doctor was not examined, you cannot take this PM certificate into account, you must throw it away. And once the PM certificate is thrown away, there is nothing to connect this driver with the death. I got acquitted. See, this is the absurdity of modern Western jurisprudence. This obsession with admissibility, procedure. So, when we say Bhartiya jurisprudence, see, for us what is important? Truth is important. The substance, the kernel is important. So that is why we say, let us go back to Bhartiya jurisprudence. Friends, in the beginning itself I said, I am an applications man. Whenever I get an opportunity, I just invoke our principles. I'll give you only one other case law which was dealt with by me some 2 or 3 months back. There was a case where a municipal employee had given a resignation letter. Then that person abandoned the service. Several years later, she filed a writ petition and that came before me. The council said, it is true, I gave a resignation letter, but orders were not passed accepting the resignation. Therefore, it must be deemed that she is continuing to be in service. That was the argument. But then, in another, the state and subordinate service rule, there was one rule which said, passed, by the end of that notice period, it is deemed to have been accepted. Of course, there is no corresponding rule in the municipal service. There is a principle in our Mimamsa, Atidesha, the principle of Atidesha, which says you can apply a rule to analogical cases. So I invoked Mimamsa, the principle of Atidesha, and said even though in the municipal service rules there is no corresponding rule, I will still derive inspiration other rule and say your resignation letter was deemed to have been accepted. Friends, I got inspiration for this from Justice Markandeya Kadju. Just as I told you, go to Rama Joyce, go to Justice V. Ramasubramanian, go to Justice Abdul Nasir. Same way, I request you, please read some of the judgments of Justice Markandeya Kadju. I will, through email and circuit, give you the citations also. Whenever possible, he will say, why should we follow Maxwell alone? Why not Mimamsa? This question, Markandeya Kadju has been asking in many cases. And whenever he could, he would invoke the Mimamsa principle and find a solution. See, in fact, I came across judgment yesterday, AR 953 Madras, where an allegation was made. And the judge, rejecting the allegation, said, there is a Mimamsa principle which says, mere assertion is not proof. Even repeated assertion is not proof. That is the Mimamsa principle. So friends, the next take-home message is, let us not think of only Maxwell and modern logic. We have our own rich body of Mimamsa, a very rich body of Nyaya literature also. And whenever possible, let us fall back on it. My next thing is requesting all of you to start getting acquainted with the writings of Dharampal. I do not know how many of you have heard of them. A great Gandhian who just died some 20 years back. His essential writings have been published by Publications Division very recently. Just go through it. He will talk about Bhartiya Chitta, Manas and Kala. He will say one thing. See, our conception of time is cyclical. The Western concept of time is linear. See, our societal arrangements are different. Their arrangements are different. So, how can we blindly have their legal system? This question Dharampal will ask, and I request all of you to acquaint yourselves with the writings of Dharampal. And there is a fundamental distinction between our approach and their approach. See, for the Westerners, the world was created for the consumption, for the gratification of man, but not so for us. We look at man as a part of the larger cosmic scheme of things. See, we say love nature, love the fellow animals. See, for us, everything was based only on fundamental need and necessity, not for our petty gratification. See, our ancient Shastras spoke about showing love towards animals. Cruelty to animals was punished as an offense. So much was there. See, ours is dharma, which is preservatory in theme. Theirs is predatory in approach. So whether a predatory approach can be superimposed on a dharmic society like that of ours? That is the fundamental question that we have to necessarily ask. Friends, England and France, they are separated by hardly 1,000 kilometers. See, I have reached Kurukshetra from Madurai. It is a 3-hour flight from Madurai to Chandigarh, then a 2-hour drive to Delhi to Chandigarh to Kurukshetra. From France, we can reach London in less than 1.5 hours. Am I right? That's all. But then, the legal system of England is one thing, that of France is something else. One is common law system, other is continental civil law system. Because their societal arrangements are different. When England and France will have two different kinds of legal systems, India, that is so far removed, why should we blindly have that English system? That is the moot question that we are asked. Our language is different. Our way of food cooking different, dressing different. The families, for them it is individual, for us it is family, for them it is right, for us it is duty and responsibility. Everything is fundamentally different. How come the legal system alone be one and the same? That is the question that we have to ask ourselves. See, we are the 75th year of independence. We are in Kurukshetra, the holy battlefield where dharma triumphed over adharma. At this stage, I'm coming to the final part of my talk. I'm going to draw a mental picture before you. All of us remember the Kargil war. The terrorists were perched on the peak. The battalion was on the ground. They have to capture the peak. They have to climb up. Every member of the battalion knew that their chance of returning alive was not even 10%. They knew at least out of the 40 members, 35 will be dead. They knew that. Still, what motivates them to go to the peak and capture? I got this answer in General Sundarji's book. General Sundarji was the chief of the army staff, and after his death, his wife compiled a small book in his honor and memory. I have forgotten the title, in fact much of the contents also I have forgotten. But one passage I distinctly remember, and I am quoting it from memory. Sundarji asked, what motivates a soldier to bravely court death? Only one thing. He does not want to let down his team members. The team honor, the battalion's honor, that alone is uppermost in his mind. So therefore, he is willing to even die. See, only if there is a sense of belonging, we will do it. See, we have to one up this legal system. And how we will one up this legal system? Only if it is ours and ours own. But since we are a foreign legal system that we are following, the commitment, the conviction is not there. And that is what is huge arrears. See, recently, last year I was dealing with second appeals. I happened to deal with the case. The suit was filed in the year 1968, the year in which I was born, and I am now 54 years old. The civil case takes 30 years, then 40 years to get disposed of. And of course, there are many who say that this legal system has given us so much, should we give it up? So to them, my answer is only one thing. I recently came across the title of one self-improvement book. It says, what brought you here will not take you there. So the legal system might have brought us to this point. Maybe it could have fairly succeeded also, but it will not take us to the next one. We are now in the 21st century. The challenges are grave, so powerful. And how do we meet them? Only if the legal system is able to meet the demands of the society. And as the speakers in the previous session, I was listening to that with utmost intent. So what is the Bhartiya approach? Let noble thoughts come from every side. And that is why when I was hearing a case and an advocate called a Pakistani Supreme Court judgment, I happily refer to it because our Rigveda says, let noble thoughts come from every side. And of course, the legal system, the various statutes, they might have been formulated, fashioned some around 50 years ago during the colonial time. How do we deal with that? Friends, I have one solution. I come from Tamil Nadu, and this is the month of December. We have so many classical music kacheris, concerts. And last night as was, I have been attending one or two concerts also. And one concert was by a mandolin maestro. Mandolin, friends you may know, was made in Italy. It's an Italian instrument. But the genius of Srinivas, he died some 10 years ago. The genius of Srinivas made Carnatic music flow from a Western instrument. So the legal system that we now have, including this constitution, has been an amalgam of the features of various constitutions. The evidence law. This may apparently be a Western one, but our genius consists in making the Bhartiya music flow out of this instrument. That I think we have to do. Just as Srinivas succeeded in producing beautiful, melodious Carnatic music from mandolin and Italian instrument, I think that should be our challenge, that should be our approach. Before I conclude, I have been reading one book by Arundhati Subramanian. She is a great poet. She has written a book, Women Who Were Only Themselves. It is a book on 4 women saints, the contemporary saints. In the preface, there is one line. She says, these women do not believe in wearing borrowed plumes. They have cast aside the costumes. They believe in wearing only themselves. Deriving inspiration from those lines, Adhivakta Parishad says, cast aside the borrowed plume of Anglo-Saxon jurisprudence. Where our own proud Bhartiya Jurisprudence is the clarion call, and it has been appropriately given at Kurukshetra the right place. Thank you.
Sir, we referred you as Honorable Judge of High Court. But you yourself have reminded us by calling yourself as Karyakarta, very noble, inspirative thing you have given to us. Sir, you have quoted Ramayana, Mahabharata, Yajnavalkya, Mandukya, Upanishad, and so many other olden treasure hidden in the Bharatiya system. You inspired our Karyakartas to go through all these referred books and come up with a suggestion, changes, narrations. So, we are grateful to you. Sir, you have given one more thing. आपने अभी लास्ट में कहा नया मोड लेके हमारा न्यायांग सिस्टम में, लीगल सिस्टम में थोड़ा चेंज करके we have to meet the requirement of the society. That is the requirement of the day that you have given us a new thought. Now I request, we are again meeting here for concluding session. Now I request Sri Parimal Bhai to, sorry.
अभी आप लोगों ने सर का जूरिस्प्रूडेंस के ऊपर, भारतीय न्याय शास्त्र के ऊपर व्याख्यान सुना। अधिवक्ता परिषद अपने यात्रा में भारतीय न्याय शास्त्र को स्थापित करने में लगा हुआ है और इसमें जितने भी इस तरह के माइलस्टोन्स हैं इसकी यात्रा में अधिवक्ता परिषद के, वो हम लोग अपने स्मरण में रखे हुए हैं। और सर ने जो जस्टिस नजीर के भाषण को कोट किया है उसकी बुकलेट बन चुकी है। कुछ टेक्निकल वजह से वो आ नहीं पाई, नहीं तो वो किताब बनी हुई है, वो किताब आप लोगों को मिलेगी। और सर को भी मैं विश्वास दिला रहा हूँ कि एक तरह से भारतीय न्याय शास्त्र की जो ये स्वतंत्रता यात्रा है, उस यात्रा के इस पड़ाव को भी हम लोग कभी नहीं भूलेंगे और उसको माइलस्टोन बनाने में अपनी भूमिका अदा करेंगे। धन्यवाद।